And Summit still has a pipeline to nowhere, nothing in the ground, and our opposition is stronger than ever.
Tonight, the battle in the courtroom over the Summit Carbon Pipeline's right to use eminent domain for its project. It faced the Iowa Supreme Court. Our Dana Searles is following the arguments and joins us now to bring us both sides of this hearing. Dana.
Well, Stephanie, the Summit Carbon Pipeline is something that those against it have a lot of passion on that opinion. I've gone to numerous gatherings over the past year, and the same argument is that Summit Carbon Solutions does not hold the right to take private property. However, the company argues it is simply written in the Constitution.
A Hardin County resident is asking for an injunction on the Summit Carbon Pipeline from surveying land to determine the depth and direction of the proposed pipeline route. That's after they claim Summit Carbon Solutions entered their property without proper notice.
We're talking about the convenience of a for-profit private company in this instance to just go out and look around on the entirety of the whole property. They're not limited to where they think the easement might be. They can go in buildings, they can go anywhere.
However, Summit Carbon Solutions is arguing it is as simple as the right to eminent domain, something listed in the Constitution.
To go onto the property and just look for the metes and bounds to make sure that the easement that they're going to seek is where they say it is. That's about as simple as it could be.
People gathered outside the Iowa State House before the oral arguments, sharing stories and encouraging one another to keep fighting. One person impacted by this is Mary Powell. Powell's 103-year-old mom is at risk of her century-old family farm being impacted by the pipeline.
I remember that joyous day when they paid off the loan and the land was ours, and they thought no one can take it from us.
Summit Carbon Solutions argues that a decision against its entity in this case could bring more consequences.
It would either be an on or off switch. Either we all get survey access or none of us do. If we don't have it, then Iowa DOT doesn't have it, railroads don't have it, electric utilities don't have it.
But those against are standing strong and confident, claiming it is a basic right.
Even if your land's not impacted, just realize that if this passes, it's not a matter of if, it's a matter of when they will come and take your land from you.
The Supreme Court did not give a timeline on the ruling, but if they rule in favor of Summit Carbon Solutions, its right to eminent domain stands. If they rule against, an injunction is placed on Summit Carbon Solutions, preventing the company from surveying property at its own discretion. Stephanie?